Okay, welcome back, everyone. Are we ready to start? Okay, great. My name is Rajeshwari, and I'm an employment lawyer. I basically only do employment cases. So I'm going to speak to you about a few employment cases which have been decided in Malaysia that relate to performance, especially cases that dealt with performance improvement exercise conducted by the employer with the employee, so that you have an idea that when things actually go out of the four walls of your office, how do they shape up? Especially when matters get to court, what happens is there will be parties outside, your organization who would be involved in the matter. Example, employee, your ex-employee would have a lawyer. If he's rich, he may even have 2 lawyers, sometimes 3. I've had a matter where the employee had 3 lawyers and the employer had 4 lawyers. The employer still wanted to be one up, So, and employers also, they may have a senior lawyer assisted by a not-so-senior lawyer, and then assisted by a junior lawyer, and then assisted further by a chambering student whose job is basically to carry bags and write notes, So this will be the setup. And when you have an employee within the organization, it's all about you and the employee, rather the organization, hierarchy, the way the organization is managed, and the employee. But the moment the issue leaves your office and gets out of your company, then it becomes about the law, how the courts work, how the lawyers want to position and strategize each other. So there will be 2 sets of lawyers for start, the company's lawyer and also the employee's lawyer, and each will have an idea of how things should be done. So what Roy spoke about, I really liked what Roy spoke about just now, because he actually gave you very positive guidelines. He said and he shared all the details. Now frankly, in my opinion, if you approach a performance or underperformer in the manner in which Roy related, you probably wouldn't even have a case to begin with, because you are there as an employer to guide, counsel, coach, pull up the employee from this underperforming group to the performing group. Now, if you succeed in that exercise, voila, what is there? Next, you will have a success story to share with maybe a few years down the road, like how, Roy shared the story of his success, with one of his colleagues. But at the same time, the McLean study, 3 out of 4, I had a chance, to sneak peek at Roy's slides before. And first thing I asked him is, I don't think this is Malaysian statistics. And Roy said, yeah, it is American. I said, I don't know whether this really is the statistics for Malaysia, because do we really have 3 out of 4 underperformers who are transformed miraculously to become performers? Question mark. Whose fault, will that be? Now, the approach Malaysian employers, ordinarily take is due to cultural reasons again. We are not in this buddy culture, right? The moment you have an employer status, you want to remove yourself 3 levels above the employee. So when an employee is not performing as you would like him or her to be, the employer merely watches. Then the employer tends to give directions to his downliners to watch the employee. And then the job of managing the employee will fall on the immediate supervisor or superior of that employee. Now, the immediate superior will have double headache. One, he's already struggling with the underperformer, and that means he has extra burden on his back, and plus he's got the whole management watching him. do it right, do it right. And this poor fellow is sweating, okay, well, what am I supposed to do here, okay? Because he's not the one going out to meet the lawyers. He's not getting legal advice. The legal advice is given to the management, top management, okay? And so here we have a gray area here, right? So what happens really is that the immediate superior says, too much problem, let me just go by the book, the law. I called my friend, he said 3 warning letters is required. Then can sack already, can win the case, okay? So the supervisor or superior is all focused on finding mistakes. So he or she is looking for errors, trip-ups, okay? So he's diligently, religiously recording every mistake. Then he goes to his boss and says, boss, okay, ready, I've already done my job. These are the warning letters, this is the file, these are the instances of failure. Now you go and do what you want to do. So this is what the reality often is. But that kind of management will be acceptable if you are talking about larger organizations, maybe because they can carry the cost of 7 months that Roy spoke about. How about smaller organizations where every man in the team can make or break the team? So you will probably be more focused on turning people around to become better performers. So from underperformer, you want somebody who you can label as overperformer, if such a label exists. Okay, so let's deal with the cases, okay, that we have reported decisions. All these are. I'd like to take you back to the beginning of Roy's slide. Remember, there was a case that he started today's presentation with. Slide 1, please. See, manual sometimes works faster than electronics. Okay. Next, please. Thank you, Zambri. Now, I would like to point you to this case. Okay, look at this case. Julie Uy versus DD Asia Pacific International Limited. This is an DDI Asia Pacific is a human resource, okay, recruitment company. Okay, they deal with human HR solutions, right? Julie Uy was employed as the business development consultant, and her salary was 6,500. She was given 6 months probation by the company, and they engaged her in April 2006. Okay? Now, so 6 months probation would be ending in October 2006. What the company did was, about September 2006, they actually gave her a target, annual revenue target of 800,000. But they said, you have 1 year to fulfill this target of 800,000. Okay? So during this, following the target, Julie worked in the company until November. Before her termination in November, the company had extended her probation for another 6 months. But they did not wait. The company extended her probation. However, the company did not wait for her to complete her second extension period. In spite of that, they actually terminated her 1.5 months into the extended probation period. Now, conservatively looking at the company's actions, okay, I can straight away see some problems that the company had created. Okay. One is that they put the target on Julie 6 months later, but the companies, and the other problem the company created was they did not allow her to conclude her probation period. But in this case, the company actually won the case in industrial court. The court said the company was correct in terminating Julie. And why did the court come to this decision? The court said, look, Julie came on board in April. The company gave her 5 months for onboarding. These 5 months was for her to do soft evolution, get to know the company, get to know its clients and all that. And eventually they said that when they felt she was ready, they gave her that 800,000 target. Now, Julie's case was, she said, look, I had already brought in 50,000 ringgit in the initial months, And when the target was introduced to me, yes, I accepted the target. I also accepted the extended probation period. I have already met and discussed with this external client called Titan, and they have promised me this contract, and the contract would give me 1/1,000,000 ringgit. So you have terminated me. Her accusation against the company was that the company had terminated her 2 days before the contract with Titan was signed. That's what she said. Okay? So the court had different sets, okay, of facts, isn't it? So with this kind of facts, if you are sitting in the industrial court as a tribunal head, for example, do you agree that Julie is a poor performer and she should be someone who is to be treated as not performing or underperforming? Should she be put on PIP? Should she be counseled and go all the steps that Roy was explaining just now? Should that be undertaken by the company? So these are the questions that often industrial court faces. It turned out to be, in this case, Julie's case rather, there were some issues. The issues were that the company was not satisfied with her performance in the initial 6 months, which is why they did not confirm her at the end of the 6 months. So that was a good thing going for the company. Second, the company was able to show that all Julie could bring from Titan was just like an MOU, intention to collaborate, but it does not translate into sales. And the company said sales for us is actual delivery of an order, and we perform and we bill that sales. Until that point, everyone comes and meets us, says nice things, talks to us, but it doesn't mean anything. So Julie's contention that, look, I had this 1.2 million in my pocket and I would have met my target and proven that I was a star performer, did not hold water in the eyes of the company, and the court agreed with the company, sadly for Julie. Okay? But I never advocate you to go in that direction because, frankly speaking, I think if you want to have a sales target or any performance-related target put on an employee's head, I will suggest that you discuss with the employee from the onset. Have the employee understand why this target is necessary for the organization and for the employee. So then the employee agrees and accepts the target. Otherwise, there have been many instances where the employee comes later and argues and says, the target is unrealistic, too high, not possible to meet, okay? And my failure is caused by all excessive, okay, requirement for high-level performance, whereas the company doesn't have the mechanism to support me. So these are issues that you have to bear in mind as we move on with others, okay?